Thank you, Mr. Chairman. I'm listened with interest to the comments of the gentleman from Pennsylvania. I'm glad that he got a response, the minority got a response to their letter. I also sit on judiciary, and my chairman, Mr. Jodan, has asked me to ask you about a letter he sent back in January asking you to appear before his committee. He has not gotten a response to that letter. And so I'd ask you, can I get a commitment from you to respond to him in the immediate future with several dates that would be, during which you would be available to appear before the Judiciary Committee?
Of course I'm going to appear before the House Judiciary Committee. I understand there are discussions about scheduling that have been going on. I don't think there's any problem in that respect.
There's been no response to the letter, so I think there's some question about whether you would be willing to appear. So getting your commitment to appear is helpful, and I thank you for that.
More than willing.
Additional time.
Gentleman's time has expired.
Thank you. Good day, Mr. Attorney General, and this may be the reason that it's good for you to leave the Chief Justice and that group before each of us speak, because you would have already heard all that. I want to thank you personally for your office and your engagement on Camp Lejeune and on obviously a vast amount of litigation. That is one of the many, many jobs that falls at your feet. One of the jobs that falls at our feet here is that we are watchdogs of the executive branch. You have previously said that you are not Congress's attorney, and you've said you're not the president's attorney. And I'm assuming that you're neither our prosecutor nor our defense attorney, and you are neither the president's prosecutor nor defense attorney. And that's why today's investigation really does deal with the fact that if you're not, by definition, the president's prosecutor, but we have an obligation to see whether or not the president or a member of his family or in concert with the president's activities, in fact, need to be overseen, admonished, or even prosecuted. And so I have a couple of questions for you, and one of them is that you have not said this very much today, but you often say, I cannot comment on that because it's an ongoing investigation. And when we ask for information, you very commonly say that it is the policy, not the law, but the policy of the Department of Justice not to provide information related to an ongoing investigation. So far, I'm on track. Is that correct?
I think I've said more than that's just a policy. I think the letters we've sent trace it to the constitutional separation of powers, to Rule 6E of the Federal Rules of Criminal Procedure, et cetera. But in general, I'm in accord with what you're saying.
So one of the challenges we face is that just a matter of weeks ago, a federal judge found the actions of now special prosecutor to be so outside what he could agree to that he pushed back on a plea settlement and nullified it and sent the U.S. Attorney going back. In light of that, don't you think it's appropriate for that portion to be considered a pre-ongoing investigation and for Congress to legitimately look at the activities leading up to that failed plea bargain rather than wait until weeks, months, or years from now a case is fully settled?
Yeah. So if you'll give me a chance, first, I don't agree with the characterization of what happened in the plea. The district judge performed her obligations under Rule 11 to determine whether the parties were in agreement as to what each had agreed to and determined that they were not. Plea fell apart, as you know. There's been another prosecution, so that leads to the second thing. We are in, Mr. Weiss is in the midst of an ongoing prosecution on the very matter that you're talking about.
Okay, but Mr. Attorney General, if we believe, and we do, at least on this side of the dais, that a pattern of behavior is occurring relative to the investigation of Hunter Biden, particularly and including while he lived in the vice president's home, while he operated commingled with the vice president, and even today as he travels with the president. So in light of that, can you agree that, in fact, it should be reasonable for us to look at a number of items, including, and one that I want your answer on, and I know we have limited time, Mr. Weiss supposedly had this ability to bring a prosecution anywhere. He now explicitly has that ability. However, are you concerned, and should we have the right to look into the fact that political appointees in California and in the District of Columbia refused to, in fact, cooperate with him in those investigation that he was charged with doing in Delaware, but which flowed over into their jurisdictions? Isn't that, in fact, an example where those political appointees of the now president, that their decision not to cooperate with him creates at least an appearance of political interference with the investigation of the president's son and possibly activities related to the president?
Look, I'm happy to answer this question in hypothetical, but not in the specifics, because I have stayed out of this matter. In the hypothetical, it is the normal process of the department that if a U.S. attorney in one district wants to bring a case in another, they go to that other district and consult. It's perfectly appropriate. They do that in order to determine what the policies are in that district, what the practices have been in that district, what the judges are like in that district. But a U.S. attorney in another district does not have the authority to deny another U.S. attorney the ability to go forward, and I have assured Mr. Weiss that he would have the authority one way or the other, and I think Mr. Weiss's letters completely reflect that.
Thank you. To be continued.
Time of the gentleman has expired. Recognized for 5 minutes.
Thank you, Mr. Chairman. Attorney General,
Thank you.
on August 11th, 2023, you appointed Mr. Weiss special counsel. You wrote a letter to the House and Senate Judiciary Committees where you cited extraordinary circumstances requiring the appointment. You avoided answering the question when Mr. Bentz asked you. I'll give you another chance to answer it. What were those extraordinary circumstances?
I'm afraid I'll have to give you the same answer I gave before. I've gave as much as I can give, which is that he thought that it had reached a stage where it would be appropriate, that I had promised him that I would give him any resource that he needed, and that he asked for it. And to go further would go into a pending investigation.
Okay, let's talk about that authority. Back on March 1st, you told the Senate Judiciary Committee that Mr. Weiss had the full authority to bring cases in other jurisdictions if he felt it was necessary. On June 7th, Mr. Weiss wrote to the Judiciary Committee stating he had been granted ultimate authority over the matter, including responsibility for deciding where, when, and whether to file charges. But by June 30th, he had changed his tune and said that his charging authority was geographically limited, and it would be up to the U.S. Attorney's Office and then you to determine whether he can partner on the case, and if not, he can request special attorney status from the AG pursuant to 28 U.S.C. 515, and he had been assured that if necessary, he would be granted 515 authority in D.C., Central District of California, or any other district where charges could be brought. Let me ask you, is there some distinct legal authority known as special attorney status?
I'm sorry?
Is there some distinct legal authority known as special attorney status?
Yeah, Section 515 permits the Attorney General to sign an order to authorize a prosecutor to work in another district.
And if you had already decided that he had full authority, why did you feel it was necessary to sign that document?
I'm sorry?
Why did Mr. Weiss feel that he would need that extra authority if you had conveyed to him that he would have all that authority?
You'll have to speak with Mr. Weiss about that. I think his 3 letters are quite clear that he understood he would have the necessary authority and that no U.S. attorney could block him.
Okay. We asked you earlier about his request for this authority, and we need to know who he spoke to about this authority and when. Before he asked you in August, he had discussions about this with others at the department. Who did he discuss special counsel authority with, and when did he do that?
I'm not going to discuss internal deliberations of the department. I guaranteed that Mr. Weiss would have the authority that he needed, and the moment he asked for the authority, I gave it to him.
Did he discuss it with the Deputy Attorney General?
Again, I'm not going to get into discussions of deliberations within the Justice Department.
That is not a valid constitutional objection.
Well, that is a valid constitutional deliberation. It has to, constitutional objection. It has to do with the ability of the Justice Department to do its communications, just as your deliberations with your staff and with other members are protected by the Constitution.
Detailing who had conversations and when does not implicate the internal deliberations at the department. The substance of those deliberations, simply detailing who and when, does not implicate those.
Yeah, I'm not going to get into the internal discussions of the department or who talked to who about what. Mr. Weiss has told this committee that he well understood his ability to bring a case wherever he wanted, and I have said that he had that ability.
Do you think that the extraordinary circumstances that you cited in the appointment have anything to do with the June 22nd and July 19th testimony of whistleblowers, Special Agents Shapley and Ziegler?
I don't think it has anything to do with Mr. Shapley, no.
Gentleman,
Do you believe Christopher Wray is a competent director of the FBI?
I think Mr. Wray is a person of the highest integrity, for whom I have great admiration, who has extraordinary experience, both as
Thank
a
you.
career
And so you
prosecutor.
certainly don't think he would knowingly give false testimony to this committee, do you?
I am sure that he would not.
Are you aware that Director Wray a couple months ago in sworn testimony implicated you in a sweeping abuse of power?
I doubt he would characterize whatever he said in that way.
Well, he testified about the school board memo that you issued on October 4th of 2021, in which you mobilized federal law enforcement powers against American parents. Now, of course, you didn't put it quite like that. Instead, you found a pretext, which is stated right here in the first line of the memo. In recent months, there has been a disturbing spike in harassment, intimidation, and threats of violence against school administrators, board members, teachers, and staff. What was your basis for making that claim?
I will say again, as I've testified numerous times in response to exactly the same question, that I saw numerous reports in the press of violence and threats.
You saw reports in the press, and so you decided to instigate a nationwide law enforcement initiative?
If I may be permitted to answer the question.
Please.
Numerous reports in the media of violence and threats of violence against school personnel of all kinds.
Did you consult with the FBI director?
We received a letter from the National Association of School Boards reporting.
Yes, that letter contained anecdotes. It didn't contain data of an increase. Did you, yes or no, consult with the FBI director before issuing the memo?
I don't believe I spoke with the FBI director, no.
Why not? Why wouldn't you consult with the FBI director?
Because the purpose of the memo, as is very clear from the memo, is to ask the FBI to assess the situation, to hold meetings, and to determine whether this was...
Mr. Attorney General, you started with a conclusion that there was an increase in threats. Now, if you had bothered to consult with the FBI director, here's what he would have said. This is from his sworn testimony, that he was not aware of any such evidence. So my question to you, sir, sitting here today, is can you substantiate your claim that there was an increase? Of course, there will always be sporadic criminal activity in all quarters of society, but your claim was there was an increase. Can you substantiate that sitting here today?
I can substantiate that by the reports in the press of violence and threats of violence and by the letters sent by representatives of thousands...
That's a no. You're giving us anecdotes. I'm asking you if you had data. You also said in your memo that you were committed to using the department's authority and resources to discourage these threats, identify them when they occur, and prosecute them when appropriate. Were there any such prosecutions?
The emphasis should be there on when appropriate, and there were no such prosecutions, and that's good news, not bad news.
There were no prosecutions, and in fact, Director Wray said there were no arrests, there were no charges. So you have no data to show us that there was any increase. You didn't even bother to consult with the FBI director, and then there were no resulting prosecutions, even though you said that they were coming. So I have to ask you now, in retrospect, was there a compelling law enforcement justification for the memo?
I think you're mischaracterizing the memo. The purpose of the memo was to hold meetings, to open lines of communication with state.
So is that a no? Yes or no? Was there a compelling law enforcement justification for the memo?
I believe there was a reason to ask for those contacts to be made with state and local law enforcement.
Well, the FBI director disagrees with you. When I asked
that's
him,
not what the FBI director said.
look at it right here,
sorry.
Mr. Attorney General. When asked, do you have any reason to dispute the conclusion that there was no nationwide law enforcement justification? He said he didn't.
Either he didn't see the reports or he didn't see the National
This is a
Association of
transcript. I've sent
Schools.
you this transcript, Mr. Attorney General. So my question is this. Will you retract the memo, and by that I mean issue a formal document to the effect that it is no longer operative?
I will not, because there was absolutely nothing wrong with the memo, as I have testified several times already.
Even though
here.
your own FBI director says there was no justification for it, you will not retract it.
The memo is mine. It's my decision whether it's necessary to make assessments like this. And I asked the Bureau to make these assessments and the other.
Are you familiar with the concept of a chilling effect?
I'm sorry, I didn't.
Are you familiar with the concept of a chilling effect?
I'm very familiar, and that's the very reason.
How would you define a chilling effect
That is-
as it relates to First
That
Amendment
is the
jurisprudence?
very reason why the second sentence of the memo says
Please
that-
tell me what you consider to be the definition of a chilling effect.
That memo has no chilling effect.
I didn't ask you your opinion on whether the memo has one. I asked you what is a chilling effect.
I'm telling you that the second sentence of that makes clear.
I've read
that-
the full memo. I'm asking you, what do you define a chilling effect as?
A chilling effect is when people's exercise of First Amendment rights are chilled by coercive activity by the government, which did not occur here.
So here we're dealing with moms and dads.
Mr. Chairman,
You and I
point
are
of
public
order
officials.
with respect to the time?
Yeah.
Point of order?
The gentleman's time has expired, but it was a pretty darn important question when the Attorney General of the United States can't define what a chilling effect is, so I thought I would let it go a few seconds.
The Attorney General did define what a chilling effect is and said it didn't occur here.
I don't think he defined it, he just dismissed it. The gentleman's time has expired. I thought it was a very important 5 minutes. We now we'll move to 5-minute questions, and we will start with the gentleman from Louisiana, Mr. Johnson.
Thank you. Mr. Weiss, the rule of law does distinguish our country, but you have not upheld that. You have allowed the rule of law to erode, and that's why 65% of the people in this country have no faith in the Department of Justice under your leadership. They don't trust it. They don't trust you. The reason is because they're witnessing every day a politicized Justice Department in a two-tiered system of justice. For example, they see the DOJ, of course, aggressively prosecuting President Biden's chief political rival, Mr. Trump, while at the same time, they see slow walking and special treatment given to the president's son. That's just a fact that everybody can see with their own two eyes. I want to focus on that investigation of the Biden family. We have many important questions for you today about that. Let me just get right to the chase. Has anyone from the White House provided direction at any time to you personally or to any senior officials at the DOJ regarding how the Hunter Biden investigation was to be carried out?
No.
Have you had personal contact with anyone at FBI headquarters about the Hunter Biden investigation?
I don't recollect the answer to that question, but the FBI works for the Justice Department. It's.
I'm sorry.
agents
You don't
of art.
recollect. You don't recollect whether you've talked with anybody at FBI headquarters about an investigation of the president's son?
I don't believe that I did. I promised the Senate when I came before it for confirmation that I would leave Mr. Weiss in place and that I would not interfere with his investigation.
Okay, did you ever-
I have kept that promise.
All right. Have you had personal contact with anybody at the Baltimore field office on the Hunter Biden matter?
No.
On July 10, 2023, U.S. Attorney David Weiss told Senator Lindsey Graham, quote, I had discussions with departmental officials regarding potential appointment under 28 U.S.C. Section 515, which would have allowed me to file charges in a district outside my own without the partnership of the local U.S. attorney, end quote. With whom did Mr. Weiss have those discussions?
I'm not going to get into the internal deliberations of the department.
Oh, but you must, sir. This is important for us. We have oversight responsibility over your department, and we need these answers.
As appropriate, necessary for Mr. Weiss to have conversations with the department. I made clear that if he wanted to bring a case in any jurisdiction, he would be able to do that. The way you do that is to get an order signed by the Attorney General called a 515 order. I promised he would be able to do that, and he in his letters made clear he understood he would be able to do that.
Okay. Can you tell us about any briefings or discussions that you personally have had with Mr. Weiss regarding any and all federal investigations of Hunter Biden?
I'm going to say again, I promised the Senate that I would not interfere with Mr. Weiss.
So you have not, I'm just, under oath today, your testimony is you have not had any discussions with Mr. Weiss about this matter?
Under oath, my testimony today is that I promised the Senate I would not intrude in his investigation. I do not intend to discuss internal Justice Department deliberations, whether or not I had them.
Oh, okay, so your testimony today is you're not going to tell us whether you've had discussions with Mr. Weiss.
My testimony today is I told the committee that I would not interfere. I made clear that Mr. Weiss would have the authority to bring cases that he thought were appropriate.
Okay.
Mr. Weiss's
All right.
letter.
Okay, let me stop you.
makes
For a second
clear-
time, sir, are you aware that FBI officials have come before this committee and they have stated that there was a cumbersome bureaucratic process that Mr. Weiss had to go through to bring charges in another judicial district? You know that?
I'm not aware, but that's not true. There's nothing cumbersome about the process.
So those
All I
whistleblowers
need
are
to-
lying to us under oath? Those whistleblowers are lying?
I
Is
didn't
your
say
testimony?
that. Their description of the process is cumbersome is an opinion. It's not a fact question. All I have to do is
Okay,
sign a
all
section.
right, let me get to the fact. Mr. Weiss has been the lead prosecutor on the Hunter Biden case since 2018, correct?
I'm sorry?
Mr. Weiss has been the lead prosecutor on the Hunter Biden case since 2018. Now, here's the question.
He's been the lead prosecutor since he was appointed by President Trump.
Okay,
And
why,
assigned-
let me ask you, why has the Justice Department dragged this investigation out for so long? Does it really take years to determine if Hunter Biden lied on a federal form related to purchasing a firearm?
Mr. Weiss was a long-time career prosecutor. President Trump appointed him as the...
You're not answering the question. Is that standard procedure? Should it take that long to make such a simple determination?
I'm answering the question. Give me an opportunity to do so.
Okay?
He was charged with that investigation under the previous administration. He's continued. He knows how to conduct investigations, and I have not intruded or attempted to evaluate that because that was the promise I made to the Senate.
The whistleblowers gave us testimony about serious misconduct at the Justice Department in regards to the preferential treatment afforded Hunter Biden. Has your office requested an investigation into that?
There are well-known processes for how whistleblowers make their claims. I am a strong proponent of whistleblowers and a strong defender. We have an Inspector General's office. We have an Office of Professional Responsibility. That is the way in which complaints from whistleblowers should be and are appropriately handled.
I'm out of time. I yield back.
Gentleman yields back. The chair recognizes the gentlelady from Wyoming, Ms. Hageman. We got.
We have been investigating very serious charges made about your department and other elements of the Biden administration, which allege ignoring the law to protect political allies from being held accountable for their wrongdoing. One aspect of this allegation, brought by two very credible whistleblowers from the IRS, demonstrates a strategy of delaying criminal investigation into Hunter Biden and blocking any investigations into the corruption of Joe Biden. The whistleblower testimony notes that U.S. Attorney David Weiss in November 2022 allowed the statute of limitations to expire, even though Hunter Biden's attorney had already agreed to extend the statute on the 2014 and 2015 charges, which charges included an attempt to evade or defeat taxes and the fraud and false statements related to the $1 million that Burisma paid to Hunter Biden while his father was vice president. During a recent transcribed interview with the committee, FBI officials from the Baltimore field office refused to answer questions about the expired 2014 and 2015 tax charges because they were allegedly part of a, quote, ongoing investigation. Are the tax charges related to these years, in fact, part of an ongoing investigation?
Again, I have no familiarity with the details of this particular investigation.
So you don't know one way or the other?
That's right. I left
All
it
right.
up to Mr.
So how are
Weiss.
charges for which the statute of limitations have already expired part of an ongoing investigation?
Again, I don't know anything about this case.
So why would charges that have already expired because of the statute of limitations be part of an ongoing investigation?
To answer in the hypothetical, because I don't know the facts, often charges from previous times are used as part of an ongoing investigation to inform information about intent, about patterns and
Or
practices.
other investigations? So are there other investigations into Hunter Biden where this information may become relevant?
I think it's a matter of public record that there is a tax investigation of Mr. Hunter Biden with respect to other years. I don't
Beyond the
think that's
2014 and 2015?
beyond the ones that are where this that you are referring to. I think
Okay, Mr. Garland?
Mr. Weiss has already said that during the plea proceeding.
Okay, Mr. Garland, is it standard operating procedure in your Department of Justice for prosecutors to allow the statute of limitations to expire on very serious crimes when the potential defendant has already agreed to an extension?
So there, as I said before, there's no standard operating procedure
Okay.
here. This is
Maybe there should be.
Well,
If this is an oversight hearing, maybe there should be. Maybe you should adopt standard operating procedures to avoid this kind of a circumstance. Would you agree?
No.
Okay.
Because it's left
According
to
to
the
one of the
discretion
IRS,
of...
you've answered my question, thank you. According to one of the IRS whistleblowers, quote, the purposeful exclusion of the 2014 and 2015 tax years sanitized the most substantive criminal conduct and concealed material facts, end quote. How can Americans trust an investigation run by a special counsel who, by allowing the statute of limitations to expire, irreversibly, quote, sanitized the most substantive criminal conduct and concealed material facts?
The prosecutor in question is an experienced veteran career prosecutor who was appointed by
And we have no reason to trust him, do we?
by President Trump.
Okay. How much in terms of taxes would Hunter Biden have owed on the $1 million he was paid by Burisma?
Well, as you can imagine, since I don't know anything about the facts of the case, I can't answer
Probably
that
about
question.
$400,000. Isn't that right? I mean, you can do the math. You know the tax code.
I don't know anything about the facts of this case, so I'm not able to do the math to apply it to
And by
facts I
failing to
don't
pay
know.
the taxes on those ill-gotten gains, what would the typical penalty have been, for example, if it was someone who didn't have the last name of Biden or a D behind their name?
I'm sorry. These are all questions you'll have to direct to Mr. Weiss, and that Mr. Weiss will address in his final...
By allowing the statute of limitations to lapse, did Mr. Weiss effectively gift the tax money Hunter Biden owed for the 2014 and 2015 tax years to Mr. Biden?
to say again, the decisions about whether in this area and whether these allegations are correct are ones that Mr. Weiss will be able to answer.
Mr. Garland, one of the things you have done over and repeated over and over and over again is that to point out that Mr. Weiss was appointed as U.S. Attorney by President Trump, as though that somehow inoculates him from criticism by us. Is that really how this game is played? That if someone is appointed by a Republican, then they're supposed to be on the Republican team? Or if they're appointed by a Democrat, they're on the Democrat team? You were appointed by Mr. Biden, weren't you? Are you on the Democrat
Let me
team?
just be clear. The point of that he was appointed by a Republican counteracts the claim that this was a partisan decision to benefit Democrats.
He remained
Time of the
as a member of the Department of Justice.
Mr. Chairman,
under you.
Time of the
Mr. Chairman.
Time of the gentlelady has expired. Yields back. The gentleman from New Jersey is recognized for 5 minutes. Joe.
Thank you, Mr. Chairman.
With that, I would yield to the gentleman from New York, the ranking member, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, at the outset, let me make two comments. One, just about every assertion you made in your opening statement has been completely refuted by witnesses who have testified before this committee. Two, far from being favored, many commentators have noted that people accused of simple gun possession while under the influence of a drug, when that gun was not used in the commission of a crime, are rarely, if ever, prosecuted the way Hunter Biden is being prosecuted. Mr. Chairman, one of this committee's most important duties is conducting oversight of the Department of Justice. We are called upon to ensure that the DOJ uses the enormous amount of power it is granted in a fair, just manner that respects the civil and human rights of all Americans. The Attorney General of the United States oversees issues that affect the lives of each and every American. Violent crime, drug trafficking, attacks on our civil rights, threats to our national security, and environmental crimes all fall under his purview. That is why we regularly request that he or she appear before this committee to speak about the work the department is doing for the welfare of the country. This is how we ensure that the department stays accountable to the American people. But if it were up to the Republicans, Americans would hear nothing about any of these substantive issues today. They would hear nothing about the rise in domestic terrorism and what the Justice Department is doing about it. They would hear nothing about what the department is doing to stop hate crimes and prevent gun violence. They would hear nothing about how the department is disrupting efforts by Russia, China, and others to interfere in our elections. Extreme MAGA Republicans have poisoned our vital oversight work. They've ignored our legitimate oversight responsibilities and used their power to stage one political stunt after another. They have wasted countless taxpayer dollars on baseless investigations into President Biden and his family, desperate to find evidence for an absurd impeachment and desperate to distract from the mounting legal peril facing Donald Trump. They have fought tirelessly to stop efforts to fight malign foreign actors trying to influence and manipulate Americans through social media. They have unconstitutionally interfered in criminal litigation and attempted to bully state and local law enforcement officers. They have publicized the names of witnesses who did not further their political goals, leading to threats of death and physical violence against those witnesses and their families. They have cost any number of private institutions and companies millions of dollars in legal fees as they struggle to respond to ridiculous and overbroad requests for information and transcribed interviews. They have issued subpoenas for show without making meaningful attempts to get the information they seek by consent. They have levied low, baseless personal attacks on any prosecutor to bring charges against Donald Trump or January 6th rioters. They have attempted to discredit investigators who are not hard enough on Donald Trump's political opponents. They have supported those involved in the deadly attack on our Capitol on January 6th in an attempt to overthrow a lawful election. They have justified conduct that we all know to be wildly illegal, like the theft of classified materials and incitement to violence. And through it all, rather than try to unite the country or solve the problems that affect us all, they have sought to exploit our divisions for cynical, personal political gain. That is their goal, division. They want to divide this country and make our government appear like it's broken, because that is when their broken political party thrives. So today, I implore the public to see through the sham. I have no doubt that you will hear a deluge of conspiracy theories and baseless accusations. They will quote freely from so-called whistleblowers who have been broadly discredited or contradicted. They will viciously attack federal law enforcement. They will tell you that all 91 criminal charges against Donald Trump are part of a conspiracy, despite overwhelming evidence of each of Donald Trump's crimes. And they will attack Special Counsel Weiss, who was appointed, let us not forget, by Donald Trump, for not being hard enough on Hunter Biden. Republicans will continue doing what they've done for years, discrediting anyone who does not serve their political goals at any cost. And the shame of it is that in this hearing room, like on the House floor, where we are barreling towards a government shutdown while my Republican colleagues call each other names, we could be working together to put people over politics and to solve any number of problems affecting the American people. More than 30,000 Americans have died from gun violence so far this year alone. Guns have become the leading cause of death for children aged 1 to 17, surpassing car accidents. Domestic violent extremism and white nationalism are on the rise. We are seeing active clubs and other white supremacist groups pop up around the country. Anti-Semitism is at an all-time high. Malign foreign actors like Russia, China, Iran, and North Korea are attempting to influence our elections. Political rhetoric is causing threats against law enforcement officials to skyrocket. Our immigration court system is in desperate need of reform. Our election workers receive death threats from conspiracy theory-driven extremists. Fentanyl is filling our streets and poisoning our children at historic rates. This list goes on, and we, the people in this room, are in a position to do something about it. In fact, it is our duty to do something about it, consistent with the oath we took when we were sworn in as members of Congress. We could work with the Department of Justice and Attorney General Garland to address any number of real substantive problems facing the American people. Instead, House Republicans will use their time today to talk about long-discredited conspiracy theories and Hunter Biden's laptop. They will do it because they care more about Donald Trump than they do about their own constituents. I hope my colleagues will see reason and at least attempt to work with the Attorney General in good faith. Sadly, on the other side of the aisle, reason and good faith seem to be in short supply. In any event, Mr. Attorney General, I thank you for your testimony and thank you in advance for your patience.